stream around on Twitter, bring some other people in. That'd be cool. So this is Dark Academia, episode 3, with Rich and now my good friend Paul. This episode is titled Civil Rights and Social Capital. We're going to get into 5 different areas, well, 5.5 different areas of civil rights law and legislation, kind of explain how they came about, how they tie in, what the law looked like before all these things were passed in the late 40s through 60s. We'll talk about the laws themselves, some of the cases that came before and then after challenging them, and really how it probably affects your day-to-day life, going through life in town. Not as much on that because I think everybody here, there's basically the presumption that these things have affected our life in a negative way, and you probably see it all the time. So we'll tie some of that in, but we won't belabor the consequences because we are all essentially living it right now. We'll get into how it got this way and maybe what a resistance to it would look like. So Paul he's probably the person I spent the most time with of anyone in the last 3 years. We met early in law school, first couple weeks, and kind of hit it off right away. Have some funny stories of of our first interactions. We'll maybe tell some other time about his family and Poland and some funny things related to that. We had a lot of wild, interesting stories together over the last few years. Some of them I don't think we can really tell till we're both retired.
Yeah, I don't think we can put those on a stream for sure.
Yeah, we definitely can't put them on a stream. So they might be like memoir material once we're retired, or the culture shifts heavily. It's not stuff you can really. They're interesting. Once the memoir comes out in 50 years, you definitely want to read it. or yeah, that's all I'll say on that. So he's a kind of an early American history scholar. He studied a lot of early foundational U.S. text in undergrad. Wrote a lot about that. Really interested in history. Really. In U.S. history, particularly a lot of the legal history. He knows a lot about that stuff, a lot of the early philosophies, and I guess really kind of the deep philosophy of a lot of founding documents and what the people at the time thought, and also the surrounding culture, some things about their day-to-day lives. And he's just a good resource for all of that. And then the way it relates legally, of course, is when people would say things like, "Oh, the U.S. was always founded to be a diverse, multicultural nation." It wasn't, and we can, show you the proof. So that's
and also have a large background in Woodrow Wilson.
Yeah, big. He studied and wrote about the early progressivism too, Wilson and FDR. That's kind of how we met and got to talking. He mentioned how much he hated Wilson and FDR, and I was like, oh, yeah, me too. And then we were pretty much on the same page after that. So that's without belaboring it all anymore. If what we're going to talk about, do a quick rundown. We're going to talk some of the main areas of civil rights. So we have a segment. Here are the segments that will be presented tonight: school desegregation, the Fair Housing Act and some of the housing cases, the Civil Rights Act and some accompanying cases, affirmative action, freedom of association, how it works now and how it's basically been obliterated, and then a quick touch on interracial marriage, the laws, how laws were before, and then what happened in the Supreme Court case Loving versus Virginia. We're going to spend about 15-20 minutes on each section, so it should run hour and 20 minutes or so. Then we'll take questions after, but also if you have questions before, if anything, you need us to stop and go over anything, just put it in the chat, and then I'll address it, or Zach will address it. the best we can. Still trying to figure out how to like present and then catch up on the chat. And I have RC sending me stuff to make sure I don't miss any questions and donations and whatnot. So, all right, with that all out of the way, I'll let Zach or Paul go ahead and get started on the school desegregation and kind of what led up to that.
Yeah. So I think it's important to start from school desegregation, because a lot of the things that we see with later segregation and fair housing and Civil Rights Act, kind of come from that. I mean, Brown versus Board happens, which is the school desegregation case, happens 15 years-ish before the Civil Rights Act, 10 years maybe. So this is a lot of the early stuff that happened. But I think it's also important to look before that at a pretty famous case that maybe you guys have heard of, called Plessy versus Ferguson. And that is the case that affirmed separate but equal. Now, this was an idea that was the most common at the time. I mean, I believe it was a unanimous court that upheld that. It was in Louisiana. It was an octoroon wanted to ride a train car, a whites-only train car, and they, he brought the case and was like, I should be allowed to come and do that. And the Supreme Court upheld 9-0, no. And it's, often cited right up there with Dred Scott as one of the worst cases in Supreme Court history and all that kind of stuff. But so if you have to look at it, that is where the country sat basically right up until 1954. The country was, we don't want to live around, work around, interact with. And it wasn't just a North-South, or it wasn't just a South thing. The racism in the North, the quote-unquote racism in the North, was maybe even worse than the South, because they weren't used to living with the people, which if you think about that, the South had dealt over and over again.
They were real familiar with them, yeah.
Yeah, they knew what was going on, but the North, they were coming, like all the things you really hear, like they're taking their jobs, they'll do for 50 cents a day what you would do for $1 a day. That's where the North came from. And so then you get Brown.
Well, hang on, let me jump in on Plessy real quick. The real interesting thing, the real important takeaway from Plessy versus Ferguson, there's two big things. There's one, it was brought up that the writer Plessy was like very famous that he was 1/8 black. And the reason I think that's important is everybody pretty much unanimously decided in the whole country. Well, I wouldn't say everyone. There's always these, like, there was the radical Republicans and these people who always had an affinity for blacks. But what happened here was interesting. You had the highest court in the whole country saying somebody who's 12% black is still fully black. There was very much like the one drop rule going on here. And also what they said is that with the affirming what became known as separate but equal, they were saying if you want to have a whites only train car there, and even though it's a public accommodation or common carrier, that's fine, as long as the black accommodation is decent and relatively equal. Do whatever you want. There was still that attitude going on up until it was overruled by Brown. So you had a long history in the country of segregation, of understanding what is white. There was nobody asking when Homer Plessy wanted to ride, well, he's 1/8. Is that white? And the 1/8 is Spanish, so is that white? No, they were just like, no, dude, you're black. Like, that's it. That's all there is to it. It says whites only. You're on the other car. The other car is nice. I don't know what the problem is. So that was where we were coming from in pretty much most of American history.
Yeah.
And then, as Paul said, that went that opinion is one of the most, they call it the worst and most infamous decisions, like I said, up there with Dred Scott, of all time. So people hate it. They just constantly rail against it. And even the scholars, the people who, legal scholars, legal educators, whatnot, they won't honestly tell you. They just say, oh, it was just a bad decision. It was just wrong. It was just, how could they have got it that wrong? Well, they don't really do say that in good faith, because if you really are an honest scholar, you will look at the country, and even if you totally disagree with it, I don't understand how they cannot admit that this is at least what the people wanted. You might agree with it. You might think it's abhorrent. You might think it's the most racist thing ever. But at the end of the day, that was what people wanted, and that's what they believed in. It wasn't a mistake. It wasn't a misreading of law. This is what they believed in. This is what they wanted. This is how they saw the country. But they won't give you that side. They won't even entertain the idea that people could have legitimately and in good faith not wanted to be commingled with other races.
Yeah. And quick shout out to Wolf and Barbie there for those donations. Thank you for those. It's also interesting too, in school, in a couple of very candid conversations with a number of different professors that I would call more classically liberal. If you got them down and made sure the doors were closed and nobody was talking or listening, they would kind of admit that the decision of Plessy fundamentally was right. This idea that in America, a correct reading of the Constitution and the 14th Amendment, which is, everyone's guaranteed due process, they would admit that if you look at it in America, in the Constitution, yes, we all are equal under the law, but there's really no legal recourse or legal way to force you to mix with anyone. It was, you could, in fact, within the confines of the Constitution, just be like, no, I want to eat here and you have to eat there.
Yeah, and that's that. And that was recognized for really up until the Brown came about in the 50s. That's just how things were. So
now, I'll also add, too, this is just a side note. If anyone's interested and likes to get into arguments with people about different things, which I'm sure most of the people here do, Plessy was decided in 1896 and overturned in 1954. So if you ever just want to, just on a fun note, own a liberal when they're like, you can't overturn this because the precedent is so crazy, 40 years of precedent, you can't do that. Hit them with this and be like, oh, so you think we shouldn't have overturned, 55 years worth of precedent?
Yeah, the precedent, as we'll get into throughout some of these cases, precedent only matters if it supports what you want. If it doesn't, then you just say, oh well, that's just clearly wrong. So that's where the country was coming from. And then fast forward to Brown is really the thing that kicked it off. Well, I should go back a little bit. There was the ACLU had a strategy of attack, and what it was started with universities. There was a law school that was desegregated, and then they started to try to desegregate law schools, and then it eventually got down to primary schools. So that is an important note in the history of this. They didn't just go after primary schools because they knew they would get fierce reaction from parents that didn't want their kids going to school with black kids, right? So they started with a law school, and they said, hey, you should let this black into the law school because there's just nowhere else for them to go to law school. If in order for them to get a legal education and represent blacks, and that's what they want to do, you have to let them in. So it seemed, that was kind of the first crack, and then it ended up getting to Brown, and I'll let Paul kind of explain the rationale of why they went ahead and overturned Plessy.
Yeah, so you get the school in St. Louis, and the little, it's real famous. Like
Little girl.
the little girl wants to go to school with the white kids. And the argument that they really focused on was the idea that separateness inherently creates inequality, um, which is kind of a fiction. I mean, so the things that you see in the textbooks a lot are like the two separate drinking fountains, or where like one's real nice and one's crummy, that kind of stuff. But yeah, so it was the girl wanted to go to school, and the idea that the education she was getting at the blacks only school, the facilities, the probably the sports, and all of those things were inherently different, and then that makes what they say under the 14th Amendment, well, you can't have that. So it's a way of attacking the idea that they weren't actually equal in their separateness, which is why it's a big whole outside thing. But Plessy's never technically been overturned by the Supreme Court. It's just kind of been pushed out. So that's the rationale that they were using, is that the 14th Amendment, that separate facilities make it unequal, not being together is an unequal thing. It's kind of, I'm not getting the best.
It's it's sort of a circular argument that they bring up, that they try to make.
And you'll see this a lot. We probably should have said this earlier. One of the grander themes in civil rights, where it's confusing for law students. Well, not all of them, because some of them just totally buy into what they're told. But it's confusing for law students, and it's confusing for people who don't even have any grounding in it. Is they had this idea, I don't know if you've seen the South Park episode with the gnome underpants thieves. The idea of where it's just like underpants ?profit. The civil rights thing is kind of like segregation bad segregation no segregation. They just they have an idea in mind, and then they figure out a way to get there.
Yeah,
it's not good, it's not right, but when looking at how things are today, you kind of just have to realize that it's how they wanted it to be, with no arrows to get you there.
Yeah, they had these cases already decided. Somebody already decided that whether there was a legal justification or not, they wanted school segregation. That was it. And then they decided that they were going to push it through no matter what. Some of the other rationales in school segregation were that they were looking at like the reading abilities of black students at, say, third grade versus white students, and the black students could not read as well as the white students. So they said, this is obviously separate, but it's not equal. If it was equal, if the schools were equally good, why can't the black students read as well? Well, I mean, that's kind of a mind-boggling thing if you have any inclination towards race realism. There was also an argument brought up that it psychologically damaged black students for life, that they would forever carry the burden of segregation, that they couldn't go to school with whites. So simply being told or knowing that whites don't want to go to school with them would psychologically damage them for life. I think that's an interesting point in this era of books coming out about white fragility and, how sensitive whites are and all of that sort of thing. You had people arguing to the Supreme Court that if you don't let us come to your school, we will be forever psychologically damaged and we will never recover. I mean, that's astonishing.
RC brings up a great point there, that like there hasn't been segregation for generations now, and you're still seeing the same problems.
Yeah.
And they want to bring up other things like you know, gentrification and white flight and things like that. But in situations today, it's still fairly clear that the problems they were arguing against then weren't fixed by going to different schools.
That's another great point. So, going into how it affects social capital today, you see that the price per education per pupil has gone steadily up for results that aren't any better. You see entire school districts in Baltimore where, like 3% of the kids are literate. You see the all sorts of gang activity, fights, needing police in schools, needing metal detectors in schools. Uh, all of these they would have happened eventually, but they're being brought to white kids in suburbs now. After the decision came down in Brown versus Board, that was just a decision. Then there was another Supreme Court about how integration would work, and then there was, you've probably seen the images from Topeka, where essentially the governor in Topeka didn't want segregation to go forward. He had the National Guard kind of protect. Was that what it was? Paul, the National Guard came in. He ordered the National Guard in,
Yeah.
and then
they federalized the National Guard because the governor wouldn't do it.
Yeah, and then they had who sent in the 101st Airborne? Who was president then?
It was probably Eisenhower.
Was it Eisenhower? So there's the famous videos of the 101st Airborne marching high school kids into school at bayonet point. What was going on is the black kids went into school and the white kids stayed outside. And they said, okay, if you're going to let black kids in, we're just not going to go to school. They literally brought in the 101st Airborne to march them into the school. So it was, the school integration was forced at gunpoint. They had the busing stuff that went on where there was the neighborhoods were largely still segregated, and because this, even after Shelley versus Kramer, which we'll talk about in a minute, people still self-segregated, and there was white people essentially moved away from black. So the school districts, even with integration, were still sort of de facto segregated. So they had busing programs. My aunt tells a story when her school was forcibly desegregated. It wasn't even segregated before. It was sort of just de facto segregated because of where people lived. Her best friend, who lived like 2 doors down, got sent to the black school. They bused her every day, like an hour one way, to go to the black school, and then bust black kids from an hour away to this school to mix them up, to force segregation. And she said it was a horrible story. She got treated terribly. That she got beat up, got sexually assaulted by the blacks, got beat up by the black girls, couldn't go to the bathroom without getting beat up, got her stuff stolen. It was just, but that's what they were doing. That's what was the result in the immediate aftermath. Once that started to happen, a bunch of private schools started popping up. They're called Segregation Academies. Is the official term for them, for whatever you want to think of that. So these schools started popping up, especially in the South, and people would say, okay, if you're going to force blacks into public schools and bus our kids to the black schools and bus blacks here or whatever, we're just going to do our own thing. We're going to start our own schools. So parents would come together, start their own schools. Those got attacked. There was a case that came out in 1976 called Runyon versus Mccrary that used a very, very antiquated Ku Klux Klan Act that was part of the legislation that came out of Reconstruction that said this was an act basically that was a federal act aimed at police officers in the South who were often also in the Klan and were not on board. They weren't on board with the desegregation stuff, right? So this was a federal law that let the federal government get at these police officers, is the long story short. So they used that. They used an antiquated Ku Klux Klan Act that was, nearly 100 years old to sort of finagle this legal reasoning to say that you can't, in a private school, exclude blacks. So that was Runyon. And then there was another case. It didn't actually go very far. It was Allen versus Wright, where people were suing. What happened is people wanted to sue. They were not successful. It was sort of. I think they were trying to go too far, where blacks were basically trying to compel the IRS to revoke tax-exempt status from private schools that were too white. So it was just a huge attack, a huge effort put forth to forcibly integrate schools. And now, I mean, you still see people, they don't want to, nobody wants to do it. Like, people still self-segregate. They still do whatever they can to get away from diversity. And it's just astonishing the lengths they went through, to be honest.
Well, and an interesting thing to close this this little segment out is that the new woke culture is actually starting to bring this kind of stuff back. And it's going to be very interesting to see how that plays out legally. Because, they want... I saw an article like a year ago where a school was opening up a blacks-only dorm floor.
Yeah, the dorms.
So that they could be safe away from white people. Because it was so difficult for them to interact with white people that they needed a space that had no whites allowed. And if we were really going to get serious about like trying to play both sides of this argument, I think there are plenty of minorities out there now that would be okay with this, where like if you go into your local like liquor store, they don't want you in there. Or like you can't walk into the barber shop in the ghetto and like get your hair cut. You'll get looks and stuff. Like it's kind of natural from both sides, and I think it's something that could legitimately be done. It's just the people that want the mixing or the people who bitch about their inability to.
I think they're only going to want it one way. I think they're going to try to say we can have our black only dorm, but you can't have a white only dorm. I think that's the evolution of it, is where they're going to take it.
Yeah.
I mean, I could see them saying, I could see them saying we don't want whites here, but they're going to lose their minds if the opposite happens. They do every time. Even at the inclination that white people don't want them, they lose their minds. It's like, even if they don't live around white people and frankly don't want to, the idea of just being told they aren't wanted makes them all very upset. There's something there too. Like even if you find these non-white groups that are kind of nationalistic and have an in-group preference, when you tell them you don't want them here, man, it's like the Palestinian kid at school, when he hated the idea. He thought Jews shouldn't be anywhere over in Israel. It's all Palestine. But he also thought Palestinians should be welcome to the U.S. And I'm like, oh yeah, so in-group preference for you, but I can't have it. If I said the same thing, you think I'm an awful bigot. So they just that's kind of the nature of diaspora population. So the next thing we'll get into is Shelley versus Kramer and the Fair Housing Act. Shelley versus Kramer is a Supreme Court case, came out in 1948. Prior to Shelley versus Kramer, entire neighborhoods would have these things called restrictive covenants. They were kind of like a bylaw on a deed. How it worked is you and all your neighbors could get together, or the person really subdividing lots could put them in the deed that would say this land can never be sold to a non-white person. And the language that was, it's antiquated language, and it's kind of funny. I forget how many There's been some studies that show how many property deeds in the U.S. have restrictive language on race, and it's a huge amount. So if you live somewhere where you can look up the property records that go back far enough, eventually in one of your deeds, you'll probably find a restrictive covenant.
I'll add in, there's entire legal organizations now
Oh, yeah.
dedicated to just combing through old deeds to pull all this stuff out.
Yes.
Like, so that's how big of a problem it is. It's not just like two guys trying to fix this. It's basically in any house that was built pre-1960.
Yeah, if you have any properties that was plotted, before the Fair Housing Act, really, you'll probably find a restrictive covenant in your deed. And there's articles that come out now, law review articles, mainstream articles, about how it creates a chilling effect on non-whites to find an old deed from maybe 100 years ago that the property wasn't able to be sold to them. I came across an article, it was either the black guy or Jewish guy, who bought a house and later found that, 100 years ago in the deed it said no blacks or Jews, whatever it was. And he, this whole thing, they made a national news story, because he was so upset how it made him feel so uncomfortable in the house and all this stuff. So the language is antiquated. It would read like, this restrictive covenant prevents individuals of the Negro, Mongoloid, or Hebrew or Hebraic race from occupying this property. So they use is old school terminology. These are old, you can kind of see how this was the prevailing culture in the U.S. for most of its history, And you're going to see that come up again and again and again. We had the old restrictive covenants. We had Plessy versus Ferguson. We had the old what was the name of the laws? They were the Blood Integrity Act, which prevented interracial marriages. You see it time and time again that the country was pretty based in red-pilled for most of its history. And so sometimes I see people will make comments about how the U.S. was always doomed and it was always Judaized and founded by Masons and I personally don't believe that's historically accurate, because when you really get into the laws, you come across stuff that we'll get to when we talk about Loving versus Virginia, how the racial or the bloodline integrity laws were written in part by Madison Grant, and who was a lawyer and an author, of course. And he had these laws specifically saying white people can't marry out of their race, and you Jews can't move into this neighborhood, and all these crazy things. So the idea that it was doomed from the start, or that it was always a multiracial nation that welcomed immigrants, is just a plain fiction. If you have any amount of integrity or honesty at all as an academic, you can't believe this. I don't know how people get up there and who teach law or American history or anything else and say that in any kind of good faith, because it's just so plainly not true. So Shelley versus Kramer. A black family buys a house in a neighborhood. A guy a few blocks away, a few blocks or a few houses down, he wasn't the next door neighbor. He wanted to enforce this covenant that said on his deed, and all the deeds, they work like a contract. It's like a contract between land is how it works. So if you have a covenant on your property, it means you're not allowed, a person that's non-white is not allowed to move in there is what it means. And it also means you can't really sell it to a non-white person. But you can also enforce that against others.
It was basically... Yeah, the enforceability against others is the key to the covenant, but it was basically just you can't sell to the other, to any people listed. So it's like if you think of a traditional contract, I'll give you $10 for your bushel of apples, and so, legally that's the offer acceptance, and then there's an exchange. That's what they were doing. It was, in this case, it was a promise for a promise. I will promise not to sell to these people. You promise not to sell to these people, and then it's a contract at heart. And then brings in some property law, which is it's enforceable basically in perpetuity. And
if someone breaches, you can go to court and seek relief.
Yes.
So that's kind of what's going on here. So this guy, white guy, says, "No, I don't want this." The deed clearly says no Negroids or Mongoloids. You can't move in here. Ends up going all the way to the Supreme Court. This is, if you are on a computer, which you probably are, you should look at Shelley versus Kramer in 1948. It's right on the Wikipedia page. I have where I'm going with this. I have the actual original document, but this is a very interesting case in Jewish ethnic activism, and here's why. There was a Solicitor's General brief submitted on behalf of the United States government up to the Supreme Court. The Solicitor General in the American legal system is the fourth most powerful attorney in the country. He reports directly to the Attorney General. The Attorney General, there's the Attorney General, Deputy Attorney General, and Assistant Attorney General. Those are 1, 2, and 3. Fourth is Solicitor General, but in the hierarchy, he's kind of second, if you want to think of it in hierarchical terms, because he reports directly to the Attorney General, who reports directly to the President. Okay. At the time, the Solicitor General was Philip Perlman, a Jewish guy. He had this brief written that argued for ending racial restrictive covenants, and it was written by 4 Jewish lawyers: Philip Elman, Oscar Davis, Hilbert Zarki, Stanley Silverberg. The Solicitor General intentionally removed all their names from the brief, and the Deputy Solicitor General, the guy under him, a guy named Ram, stated that it was bad enough that Solicitor General Philip Perlman's name had to be there, but to have one Jew's name on it, and then also put 4 more Jews on it, it looks like a bunch of Jewish lawyers from the Justice Department put this out. And that's literally exactly what happened. 4 Jews writing it, Solicitor General Jew, Deputy Solicitor General Jew, and this was basically the influential part of this case. Goes up to the Supreme Court. So you have the Supreme Court looking at this, and they get a brief from the Solicitor General, who reports directly to the President, that says, you need to figure out a way to make sure the racial restrictive covenants are done. So I just really, it's really important to bring that up, because this isn't a case that was decided on any sort of historical precedent on the merits of the case, on a proper reading of constitutionality or contract law, or even the Equal Protection Clause. This was a case where you have a very, very powerful group of people. Everybody who worked for the Solicitor General was Jewish, and they're reporting directly to the President, and they are saying to the Supreme Court, this is how we want the outcome to be. Figure it out. And I'll let Paul kind of explain the reasoning and how absurd it is. But that's what's going on when the decision is about to come down.
Yeah, and and this is, like I was saying earlier, one of the craziest mental gymnastics thing that they have to do. So it's important to remember, like I said, that this is basically a contract mixed with property. That's the fundamental basics, like from your law school class. It's contracts and property. And so they came up with this idea that if you have a restrictive covenant in your deed, you have to, the only way to get that enforced is to take it before, like, a state official, namely a judge. But in some way, the fact that you have to sue somebody to enforce it means that the state is involved. And because of that, you have state action. And because you have state action, it therefore is enough to be where the state can't be enforcing racial divides or, segregation. it it is one of the most comical things
Yeah, so
that
what
you
they're
learn about
saying,
just how they figure it out.
yeah, they're saying that if you go to court, it's state action. Well, I mean, what's the whole point of the court, right? If you and I have a contract, and the contract is that, you pay me $10 to wash your car, and I don't wash your car. Well, I guess that's a little bit different because they're not going to. Well, I guess what's a good
Well,
example? Because like they won't compel me to wash your car, right? Like because,
no,
but
but it's the idea
well, if you're
that
going to sell
they wouldn't
something,
get in.
if it's property, they might compel me to sell or something, right? They're going to do something.
Yeah,
The court isn't just going to let me screw you over. So therefore, it's state action. But that doesn't mean the state is making me sell my property or wash your car or do whatever. That was our contract. And the state is just figuring out a way to make sure contracts are upheld. But in this case, they said because we have to read your contract, it's state action, and states aren't allowed to discriminate against you. Therefore, question mark, question mark, question mark, bam, no more racial covenants. So it's a legal fiction. When you are in law school and this case comes up, they will tell you how horrible and racist it is and how it was so mean and blah blah blah. But but then they gloss over the legal reasoning. You say, wait, hang on a second. How is it legal action that they had to enforce a covenant? Isn't it legal? I mean, you force other contracts. Like, why are those not an issue? So that's where I got that. What's the X tag thing? Is there something D-Live team here? Controversial.
Yeah, I saw that because it's controversial content.
How do I add an X tag?
Not that I don't know. Does anyone in chat know how you? I'm sure there's something that's just like, hey, this is sensitive, which at least it's just getting flagged as sensitive and not like.
Yeah, I'll switch over soon. So, all right, that's.
We'll try to keep it PG as PG.
I mean, I don't know what the heck. I'm just a classical liberal that is talking about legal history. What's their problem? So, Shelley versus Kramer outlawed racially restrictive covenants. Can't have them anymore. There was a lot still in deeds. They're still in deeds now, but they're unenforceable. If you create one now, you will be in violation of Shelley versus Kramer, which only means that if you try to enforce it, they won't let you. But also, fast forward 20 years, the Civil Rights Act of 1968, introduced by Emanuel Seller, who also did the Immigration Act, Voting Rights Act, a bunch of civil rights things. He was backed by the American Jewish Congress, American Jewish Committee, some Eastern European Jewish organization, and like a dozen others. They basically took the heart of Shelley versus Kramer and made it the Fair Housing Act, but then also expanded it. And like I said, 2 decades later. So it wasn't just that you couldn't enforce a racially restrictive covenant. Now there's all sorts of things. You can't discriminate in housing, in rentals, in who you sell to, and a realtor isn't allowed to decline to sell to a black person. There was a case about that. And there's basically very few exceptions, and this is really enforced heavily through the realtors. If a realtor, let me say it this way: if you go to a realtor and you say, "Hey, I want an area with good schools," you know what I mean? Like, I don't like when people. I don't want to live in a neighborhood where people are playing a lot of rap music. You know what I'm saying? And if the realtor gives you an honest answer, they can lose their license by violating the Fair Housing Act. So the people who they can't even really tell you the racial makeup. There was a case about that. There was a case where a woman had like a biracial kid, and she was like, I don't want my kid to be the only black kid at school. There are a lot of blacks here, and even the realtors were like so afraid to answer it out of fear that they would violate the Civil Rights Act by, making any comment on race. It ended up being there was a whole case about it. But they being the realtor associations and the licensing groups, basically say you can't answer that. Not only that, they might tell you they can't do business with you if you are even asking about these things, about the racial makeup of the neighborhood. Is it a good neighborhood? And getting at that, they might just say, no, sorry, we can't. This firm can't help you. Or what are they called? Are they called firms? Realtors?
Just realtors, like
a
realty
group.
firms.
Maybe it's a group.
Yeah.
So, a couple small exceptions to the Fair Housing Act. If you live in an apartment building that only has 4 units, so you're one of the units and there's 3 others, you can exclude people based on race, ethnicity, but you can't advertise. You can't advertise it. If you do any advertising for rentals or for selling a house, it has to comply with the Fair Housing Act. Even if it's your own house, your own property. Even if it's you're renting out, you live in a duplex, you're renting out the other side. If you do any advertising at all, you can't discriminate. You can't advertise and then only pick white people. If you do, you're going to run afoul of the Fair Housing Act, and I don't really know what the consequences are of doing that. They can probably force you to rent. There's maybe fines. I'm not sure. Do you happen to know what happens when you...
I actually don't. I'm sure it's fines. Because I have to feel like they can't force you to rent it.
Oh, yeah, I just looked.
There's
a penalty. There's fines, yeah.
Yeah, I mean, they do force you to do things, but because it's property-based and not, like, association or other based, they can't just, like, make you, give up your property. But,
here's
the
fines. Maximum penalty, $16,000 for the first violation, $35,000 if there's another violation, and if another one occurred within a 5-year period, 3 within 5 years, $65,000. So, huge amount of money for violating this. So not only can they sue you for it, get you to they'll drag you into court. You have to prove that you weren't violating, and some of this is presumed. Like is this one of the ones where there's like the presumption that it happened and you basically have to prove it didn't happen? Remember there's a few of those?
This is one of the ones where it's a baseline presumption that if they're coming in and complaining about it, that you did it.
Yeah.
And you have to show you didn't.
So the way it's written, you're immediately on your heels. If you're a landowner and or own some properties, you're immediately on your heels, and it gets thrown in your court immediately. It's not like they have to prove somehow that you discriminate against them. They basically allege it, and you have to go in there and show you didn't, Oh, man, and you get these heavy fines. $16,000, like, for the first time? Man. I mean, I don't know what to say about it other than cause white flight, cause the destruction of neighborhoods, makes the cost of living go way higher. I mean, everyone's experienced it. Everyone's experienced a neighborhood that was nice that went downhill, and this is a very, very direct result. So that's kind of the fair housing stuff. And the Fair Housing Act, Shelley vs. Kramer. So,
what do we got up here next?
Let's do. Do you want to kick off with the Civil Rights Act, Commerce Clause, Heart of Atlanta?
Yeah, I mean we can jump into that.
Yeah, let's do. Let's get into civil rights stuff. So that's so now you know how schools got integrated, how housing got integrated. Now we're going to talk about why, you have to bake the cake, bigot. That case is a little interesting because it kind of got. He didn't have to bake the cake because it was a custom cake, but he would have had to serve him. So that case is a little bit confusing for people rightfully so because of the legal reasoning. But this is why you have to rent the motel room, bigot, serve them at the lunch counter, bigot, all that stuff. So we'll explain how that why you can't. There's yeah. Go ahead. I'll get into some of those stuff after you kind of run over. So just talk about what the civil rights does, explain the wild commerce clause, and then maybe Heart of Atlanta motel.
Yeah. So I want to start with this little hypothetical that I've come up with, and I'd like the people in chat to see if you can come up with like actual ideas because I've never been able to figure this out before. So imagine you had two apples in front of you. One is like a nice, perfect, fresh picked apple. The second apple is like 3 weeks old. It's like rotting. It smells. There's bugs on it. It's just like physically disgusting looking. And now you have to say why you have to give me a reason why you would not eat the old, disgusting looking apple, but you can't tell me why by describing its taste, its look, its smell, or how it feels. It's hard. Like the best that I've ever been able to come up with is health. Like, okay, it'll make me sick. But when there's a lot of things when we're dealing with this, when it's like you know it when you see it, you just feel it in your gut. You can't come up with a good reason why you don't want to live next to people or interact with people because fireworks going off at 2 a.m. isn't a legitimate reason. That kind of thing. So when you get into the Civil Rights Act, Heart of Atlanta is a great case to start with because it was a little motel.
It was a challenge to civil rights. Make sure that's so confusing.
It was a challenge to civil rights. So it was a little hotel on the side of the highway, and they were segregated, obviously, because it's in Atlanta. It's like right on the way into Atlanta. I want to say I'm pretty sure it's still there.
Yeah, I think it might be.
And so they were segregated, and people wanted to stay there. They weren't allowed, so they took it to the Supreme Court. And then the rationale that the court uses for this and for a lot of other civil rights cases later is the Commerce Clause, which is right in Article 1 of the Constitution that the Congress is allowed to regulate interstate commerce. Now, they took that and applied it to this case and said, by not allowing people, minorities, traveling to this area to stay at the hotel, you're adversely affecting interstate commerce because that's money not coming in. They don't have anywhere to stay, so they won't travel, or it's that by not allowing this to happen, the economy is somehow affected in a way, and then through the 14th Amendment, we can't have that type of discrimination.
Yeah, that's what commerce, like that was the justification for that was the power that the Civil Rights Act was passed under, was Commerce Clause. So they're saying by discriminating against people in hotels and restaurants and bars, you are hurting commerce. That's what they're telling people. And the people were saying, well, we think by not discriminating, our business is going to be hurt. We think, they're going to steal from us and bother white customers and whatnot. And, I don't have to tell you all how that worked out.
Yeah. And so it's an interesting way that they're doing it. And I'm pretty sure in the last episode, Rich had mentioned just how the Commerce Clause has exploded.
Yeah.
And the things that they've done, not related to this subject at all, but an example of how powerful the Commerce Clause has gotten and how you can see they apply it to this is there was a situation where the federal government was cracking down on marijuana sales completely interstate. So it was a guy who had like 3 plants, growed it,
For their own
sold it to
consumption.
like
For their own consumption too,
their own
wasn't it? Yeah.
consumption. Yeah, or maybe like selling it to their neighbor or
Mm-hmm.
something. And their argument was, okay, but you consuming your own homegrown marijuana is actually affecting the illegal marijuana market because you're not a participant in it anymore.
Yeah.
Therefore, it's interstate commerce. So you can see that they can just do anything they want with this. And that sets up why they can use it so heavily in bake the cake, serve the person, let the tranny work at the mortuary. That was a case that just got solved the other day, or this last session. And it's because in the global economy that's become the US, with no basically states having their own economy, it's all national. They can basically say anything you do, legal or illegal, affects commerce. And then therefore, because we have the power to regulate it through this Civil Rights Act, we can do just about whatever we want.
Yeah, and that's basically Civil Rights Act and the challenge to it. The Heart of Atlanta challenge was so this is, of course, after the Civil Rights Act came down, 64, Manuel Seller, usual suspects. Heart of Atlanta was still doing segregation, like Paul said. And they said, hold on, you're getting out of control. Like, this Commerce Clause, you can't tell a little motel what to do. Like, I thought we had rights and private property. And they brought up all these points. They brought up private property. They brought up a due process issue. They brought up an involuntary servitude issue by basically saying, you're forcing me to serve people I do not want to force. That's the 13th Amendment. It's a 13th Amendment issue. And they brought up all these challenges. Some were interesting. The Fifth Amendment challenge was novel and interesting. Basically said, you're telling me what to do with my property in such a way it amounts to a taking. And that wasn't... All those arguments were shot down. They basically said, no, it's not a full taking because, we're not taking it for public use. We're just opening you up to a public use. You're still in control of your own property. We're just modifying it. And they said it's not involuntary servitude because reasons. That was a strong argument, saying you forcing me to serve people I don't want to. And they brought up a freedom of association argument too, where they said, hey, what about, this is private property, what about my right to want to serve only whites? Like, don't I have the right to associate with just white people? And this sort of starts to tie into freedom of association, because it's widely recognized that since the Civil Rights Act of 1968, freedom of association regarding housing, education, and businesses, even though it's totally private owned housing, private schools even, and privately owned businesses, that the Commerce Clause can trump your freedom of association. So at heart, what is being said that nobody will really tell you is that the American government has said throughout the 60s that that's cool that you have a long-standing historical right to associate or not associate with whomever you wish, but we think that money and racism supersedes that. And then the interesting thing about money is, I kind of circle back around, is how many places do you personally know that went out of business because the area turned bad? How many malls do you not shop at because the area turned bad? How many stores went out of business because the area turned bad? There was a bunch of allegations against a Kroger, a chain of grocery stores. They alleged racism against Kroger because Kroger started pulling out of areas that were black, according to the people saying they were racist. Well, Kroger released a statement and said, we didn't even look at the demographics of the area we pulled out of. We were pulling out of stores that had the highest percentage of theft in our entire company. So I actually went to one of these stores before they closed down, one of these Krogers, and I saw a black woman there with a stroller pushing her kid. She opened up a pack of diapers, took one out, changed the kid's diaper, used some of the wipes, pulled them right off the shelf, used the wipes, put the dirty diaper back on the shelf, and then kept on shopping. I saw that with my own two eyes. There's a Kroger, I forget where it is, but it's called the Murderer Kroger. You can Wikipedia Murderer Kroger, and it's a Kroger that got that nickname because there was so many killings inside the store and in the parking lot. So Kroger left these places, right? They say, look, you can't do this. We can't operate in this condition. So the justifications of using Commerce Clause for civil rights has way exceeded its alleged usefulness, and we're to the point where 60 years later we can see that the Civil Rights Act and the Commerce Clause didn't actually help commerce. Places are, if you let anybody move into your neighborhood, property values drop. If you don't have a way to keep out riffraff, you have all kinds of problems. There was a bar near me, off campus. They were having all kinds of problems with girls being roofied, with guys getting jumped, with people's cell phones being stolen, with fights. So they put up a sign that said, you can't wear basketball jerseys, you can't wear Timberland boots, you can't wear gold grills, you can't wear big chains, can't wear flat-billed baseball caps, because these are the people we noticed that keep roofing girls and raping girls in the bathroom and beating up dudes in the bathroom in gangs and selling drugs across the bar, and we just can't have you in anymore. And then a bunch of the NAACP and ACLU and all these groups, are the local chapters, chimped out, and they were like, oh my God, you're talking about blacks. And then the manager of this bar was just like, no, these are just the people we noticed doing crime. And they're like, oh, you're talking about blacks. You just want to keep blacks out, right? Well, it's like, yeah, but he can't. He knows he can't say that. So he tried to, we live in a society where you have to sort of describe what the criminals were wearing and hope that they won't change their clothes and still come into your bar, right? Like this, what are the guy's options? Just let his good paying, good tipping customers get roofied, get their phones stolen, get their purses stolen, get attacked when they go into the bathroom. These are the consequences of this kind of stuff. It's some of my, my favorite childhood pizza place, closed after 50 years. The area got diverse because the schools, the neighborhoods, and the restaurants couldn't keep out riffraff, and they got robbed 3 times. And on the 3rd time, the guy got shot. Gave him the money every time, shot him in the stomach just for the hell of it, just because that's what they like to do. They thought it was funny, I bet. And so we see, all of the justifications. So Brown versus Board, blacks will get a better education. The Fair Housing Act, that it's commerce, and Civil Rights Act, that it's commerce. So we see the blacks aren't getting a better education in an integrated school. We see in neighborhoods that the housing values go down when you can't keep things exclusive. We see in the Civil Rights Act that businesses have to spend more and more money on security, that retail theft goes up, that it makes it more and more difficult to survive in a very diverse society. So everything that was ever used as justification for essentially the destruction of a homogenous society has been totally and completely and thoroughly undermined by the results.
Yes.
Yeah, and that just...
But back to the Apple question, saying those things is not enough to get you past any standard. To say they're stealing the purses, roofing people. They're loud at 3 in the morning for a house, or they are loud at the tables of our restaurant. And these are things that a normal person kind of realizes that just quiet enjoyment of life, and to just not like this freedom to not be bothered by things is not enough to break through as a reason why to disinvite people.
Yeah. It's so that's where we are. Let's you want to run through affirmative action? Do you want me to do it, or do you want to do it?
Yeah, you take affirmative action. I'll jump in.
All right. So affirmative action. This is another civil rights idea. Affirmative action is not one policy. Affirmative action loosely refers to a cluster of policies and maybe laws, maybe internal procedures that is aimed to redress so-called historical grievances and to promote diversity in education and the workplace. Companies, government in hiring, and schools have enacted different policies to achieve higher diversity and make it so that non-whites have a more fair shake, I guess.
Well, and to have a fair shake, and also tied into that they have argued that everyone has a better experience.
Yes.
When there is diversity. I mean, it's the cliche that we see all the time now, but it's the idea that diversity in a school makes it enriches it because you're getting different viewpoints and all of that.
Yeah. So one of the first cases that goes up to the Supreme Court is against the Regents of the University of California versus Bakke in 1978. And this is an important case, and it's used very subversively. The decision by the Supreme Court was that in a college admissions policy, you could not use a hard quota anymore. So in this particular case, it's the University of California Davis School of Medicine. Guys tried to get in, can't get in. He challenges this on an equal protection issue. He's saying, hey, you're kind of discriminating against me for being white, right? The way it worked is there was 100 seats available for med school. 16 of the 100 were set aside for non-white students. This is in 1978. I'm not sure what the racial makeup of California looked like, or
that feels like a national.
Yeah, it feels like
fall into national.
Yeah, it feels like that was kind of a national. They looked at 16% of the people are not white, therefore 16% of our seats should go to non-whites, was what they were doing. And the Supreme Court said, no, you can't do a hard racial quota. That looks a little bit too much like you're discriminating. Now, the reason I say this is it's a good outcome, you would think, right? But the reason I say it's used subversively is because I had a sociology professor one time and was talking about how great affirmative action is. And somebody was like, well, what about the idea of racial quotas? Isn't that sort of just discriminating against another group? And she was like, oh, no. Affirmative action, you're not even allowed to do racial quotas anymore. Like, we don't do that. And so the problem is that quotas are still used. They just aren't allowed to say it because of that case. So,
well, I don't know. I'm not sure if you were going to jump into this, but the holistic approach,
yes,
the Harvard approach,
right? Is
what comes out of this.
Yeah, that's what ultimately comes out of these cases. So, fast forward, you have a couple cases in 2003. The first one's called Gratz versus Bollinger. It's about getting into the University of Michigan. The University of Michigan had a policy where if you, on a scale of 1 to 150, if you get 100 points, you get into the university. But non-white students automatically got 20 points simply for being non-white. And a Gratz, a Jennifer Gratz person applying, didn't get in and challenged this. And what the Supreme Court said was that no, giving them straight 20 points out of 100, giving non-whites 20 points out of 100 feels a little bit too much like you're deliberately disadvantaging whites. This also seems like it's a good thing, right? Like on its face, you think, oh, that's good. They're saying you can't just straight discriminate against whites, but it gets more subversive. And there was another case decided came down at the same time, Mccrary versus Bollinger, and that ruled that you could use race to determine your admissions, but you can't use a hard quota and you can't give them straight points. If you give them, the students, non-white students, straight points, you're not looking at them as an individual. It still looks too much like a quota. So you can use this, what they call holistic approach, which Harvard has done for years, where your race or sexual orientation or national origin is one of many factors that goes into what we call a holistic approach to use to reach what is called a critical mass of diversity, which, so here's now taking these three together, here's where you see the subversiveness. Nobody has to define what a critical mass of diversity is, and nobody has to really give any weight to what this holistic approach is. So before, you could say you get 20 extra points for being black and 16 of our seats go to blacks or whatever, right? And that looked bad. But what's going on now is the same thing in effect, but when schools meet and publish, if they do publish admissions criteria and how they admit students, they just don't say it. They're doing the same thing. They're still preferencing certain groups. But they just aren't publishing it. So the Supreme Court basically told schools that, yeah, you can favor non-whites and you can, have a bunch in, but just don't publish it so that the whites don't know you're discriminating against them. It's very sneaky. It's very subversive. In this 2003 case, last time this stuff was up, the opinion said that this is fine for now, but at a certain point, we probably aren't going to need any sort of affirmative action.
Years.
Yeah, they said maybe in 25
Sandra
years.
Day O'Connor said 25 years, you won't need it.
Yeah, they said you probably won't need it. And then Ginsburg and Breyer, two of the Jews on the court at the time, they concurred in the judgment, meaning if you see a concurrence, that means they agree with the outcome, but for different reasons. They wrote a concurrence and basically said that we don't believe affirmative action will be unnecessary in 25 years. We should just keep it on going, which is a very interesting note in that history. So the way affirmative action now works in theory, according to constitutional law, is that you can't have a hard quota and you can't just give people points for being non-white. The way it works in practice is they have hard quotas and they give people points for being not white. They just don't tell you. That's it. They'll say if it just made them very clever and sophisticated. That's it. Maybe Harvard says, we don't admit people just because they're Jewish. We don't know why they're overrepresented. We picked so-and-so because they played tuba and we didn't have any tuba players this time. That's it. That's how it works. And
it's the diversity of the background that goes into this approach, but it's easy to see where this comes from because you write your admission letter or you check all the boxes like mom's a bagger of groceries, dad I don't have one. Me and my 6 brothers lived on 5 cents a day, like school lunches and all that. And so it's basically this idea that like it's taking your story and then you pair that person with the person who's like, my dad and mom are both psychologists and went to Harvard, and so then they take those two and they're like, okay, now you're mixed now. But it's easy to see which ones are which.
Yeah.
And because something like Harvard is the way it is, one of the reasons I would say that there's overrepresentation is that they're making up probably 50% of their population on legacies.
Yeah, they're doing a
And
lot
the
of legacy.
legacy of Harvard is what it is.
Yeah.
So if you just pick your legacies and that's your white students, and then you just get the saddest stories basically for your other 50%, that's how it works. It's an easy way to see the people that you want,
Yeah, and
because roughly the the bell curve is no dad, single mom, six brothers is one group, and two doctors and your grandfather was a senator is on the other side. Like,
yeah. Um, so if you were trying to get somebody to explain this, it would be like holding sand with a closed fist as it escapes through your fingers, or nailing jelly to a wall. There's, it's hard to argue it now. These cases had, in effect, made it really impossible, difficult to challenge affirmative action in school. The way it works in companies is, what are some of the cases? Do you remember how some of those are? I mean, because if it's a government institution, that's a little different. Like, it has to be aimed to address redress a historical discrimination, and kind of
yeah,
narrowly tailored. Has that kind of a high scrutiny. As far as other companies, basically diversity is viewed as a legitimate hiring metric, and I think that everyone is savvy enough now that they're not going to come out and say, we have a hard quota, but they're going to say things need to be more diverse. There was another place where Ginsburg dissented in one of these cases, and what Ginsburg said was that affirmative action shouldn't get such scrutiny, that the Supreme Court should let people do affirmative action as they want, because there's a difference between inclusion and exclusion. And what she was saying is that if there's a policy written to exclude a certain group, it should get the highest scrutiny, strict scrutiny, which means the government has to have a compelling interest for doing this, and it's the least restrictive means. Which, by the way, I think, like housing restrictions in non-clown world would pass strict scrutiny. I think keeping your neighborhood safe is a very compelling interest, and I think by saying some people can't come in is not, frankly, not restrictive, because you're not really doing anything to them of saying you don't have a right to access these people. That's a non-clown world interpretation of it. So what Ginsburg was saying is that if it's an exclusive policy, it needs to be very, very strict. But if it's an inclusive policy, we should just do like a rational basis, like let them do it. And I thought that was interesting because it has an internal contradiction in that if you have a finite number of seats available for, if you have 100 seats available, or 2 jobs available, or 5 jobs available, and you make it a point to include one group, you're necessarily excluding the other group. You can't just let everybody in, right? And I read that and I thought, wow, that is the kind of reasoning that these people come up with every single time. Like they just can't help themselves. So,
Yeah.
do you have anything you want to add on school or work affirmative action?
No, I think that's a good little rundown of it. I mean, it like I've been saying over and over, it's kind of hard to really delve into this because it just is. Like a lot of these things, it's kind of like God. It is what it is.
Yeah, some of these cases, and the Supreme Court has that mentality that this is just this is what we want to do, and everybody else, mainly law professors, needs to come up with some sort of semi-reasonable post hoc explanation. Sometimes they don't even really rationalize it very well or apply law. They're just like, yeah, whatever. We just, whatever. This is what we want to do, and it goes.
Yeah.
So, um,
So we're at about an hour and a half right now.
all right, let's run
Just
through
wanted to,
these last couple.
yeah, be able to take some questions. I guess if anyone wants to throw in questions while we do this last little section, we'll get to those
Yeah,
afterwards and try to wrap up here so we don't take up more of anyone's time.
sounds good. So I'll just run through. Let's run through Loving versus Virginia. Loving versus Virginia is the case. Supreme Court case is the reason that states or the government cannot have a ban on interracial marriage. There were laws in place that wouldn't grant marriage licenses. Basically, you could be in a relationship, but you couldn't get a marriage license in an interracial marriage. Like I said before, Madison Grant played a big role in these acts. They were different. They were called different things in different places, but it was essentially to it worked to put a chilling effect on interracial relationships. You could still, it wouldn't be illegal to have sex with somebody of another race or have a kid with them, but you wouldn't be viewed as legitimately married by the state, and you wouldn't get the benefits that come with marriage, and you could never say you were married. You were basically always just kind of shacking up, right? Like your family was always sort of inherently less legitimate, and it carried a social stigma with it and had the effect of really dissuading people from marrying outside of their race. One of the rationales used to strike it down by the Supreme Court was that it didn't apply equally, as if they cared, because it was only for whites not marrying non-whites, but an Asian could marry a Mexican, or a black could marry a Mexican, or whatever. So they were like, "Oh, this isn't fair. This is so mean to whites. You should be able to marry who you want." The lawyers in the case that took it up, Bernard Cohen, Philip Hirschkopf, both Jews, they didn't care that whites couldn't. They weren't doing it to help whites out. That's. Do you remember the reasoning? There was some other reasoning. It was a 14th Amendment thing. So they were basically saying it's not fair that.
I mean that's really
it wasn't
what it
fair
came
that
down to.
and they were saying it wasn't totally fair under. Yeah, that's what it was. It wasn't totally fair under the 14th Amendment. It wasn't equally applied. And one of the rationales of how it wasn't equally applied was that it sort of only applied to whites. And so I remember thinking when I'm hearing that case, and like, why didn't they just say, blacks have to marry blacks, whites have to marry whites, whatnot? That would have been almost got around the reasoning for why they struck it down. But that wasn't what they wanted to do. Was they wanted a universal mix-up of their little gray people. So
Yeah.
that Supreme Court case ended the ability for states to deny marriage licenses to people from different races. The freedom of association stuff, like I said, it's been destroyed. Housing.
Yeah, I mean there's
Go ahead.
for just a quick little hit on freedom of association. They've basically said that yes, it's a fundamental right, but it is also
They carved out a ton of places.
yeah, they've carved it out and said stopping discrimination is also fundamental.
Yeah, that we
And
have.
so,
That's what it was. We have such an important interest in stopping discrimination. We have such a compelling interest. We're not going to let you do it even privately.
yeah, so there was one major case where they came up with that, and that was Roberts versus U.S. Jayless. Um, but then in subsequent cases, they've kind of come up with these factors. Um, this idea of membership. If your membership gets over a certain amount, the government can force you to open it up, and that's it, set at 400. So you could just be having your little group, and then you got 1,000 people that all believe the same thing, um, and then it's gone. And then the government says, nope, somebody wants to join. You saw this kind of like in a way the BMI case where they said you have to let women in. This is the kind of stuff they're using for the trans athletes, I believe. Um, but so if you're just, keep in mind if your membership is small, or like, 15 guys get together on a weekend and they're like, no women, or, we just want this particular ethnic group, you can do that. Um, and it's interesting that they did make this distinction, because I believe the Ku Klux Klan sued them on grounds of this, and they said, well, our purpose is discrimination.
Yeah.
The reason we have a group and all these people are together is for discrimination. And the court actually did say that if your group's purpose is for discrimination, you are okay. Which is how I'm sure some of you remember the Boy Scouts of America case with the gay scoutmaster. The Boy Scouts argued we are anti-gay,
Yeah.
and that's what they won on. They won on the purpose of our organization is to discriminate against gays, so we can keep out gay scoutmasters.
I wanted to ask you. I was reading that case again where I saw, okay, they let them. Do you think that because sexuality is not a suspect or quasi-suspect class, that is why they let them do it? Like why the Boy Scouts won that case?
Yes, and I don't think it hurts that it was 20 years ago.
Yeah, I was thinking about
I
that.
don't think they would win at this point on saying. I think because one of the things they argued against in that case, the other side, Dale, the scoutmaster, said, well, the Boy Scouts nowhere have listed like specifically like we're anti-gay, where like the KKK quite obviously has its message like branded out there. And so the Boy Scouts had to just use, that like religion is a central idea to scouting and all of these things, like morally clean and things like that. And that's how they argued, hey, we are anti-gay. But I don't think that would fly today, especially in a sexual orientation setting. You would have to be out there like burning pride flags like at your rallies to
To say
qualify,
yeah.
I believe. Yeah.
So that's so freedom of association said doesn't exist in housing, education, or businesses whatsoever. If you are trying to disassociate with people of a different race, religion, national origin, alienage, or really gender, a little bit less. So it's the club. So like, we talked about the Boy Scouts where they said it was okay. The private clubs, depending on the purpose, the membership size, and whatnot, you may be able to discriminate. I wouldn't do it based on any of those suspect classes. I would, if you wanted a club to only let your friends in, or made it wider known, I would make a club where you have to be into like sailing, restoring and sailing Viking ships, and an appreciation of two-door architecture. You can. That would be if you wanted to make a club where it's kind of restrictive. Let's see yeah, because even private clubs can be opened up. So the other thing is we'll hit Masterpiece Cake real quick. It's bake the cake bigot case. The Supreme Court sided in favor of him because of the speech amendment, or the speech issue. Who else? Ginsburg and who else dissented to that? I forget. Do you remember?
Well, 4 of them did. The four
liberals. Yeah.
Yeah.
So
Ginsburg, Sotomayor. Oh no, I'm sorry. I apologize. It was Ginsburg and Sotomayor dissented.
Okay. So,
but there was a ton of concurrence. It's a very ugly case.
It is.
Like, everybody's kind of agreeing and kind of not agreeing.
Yeah. Basically, what people need to know about that case is that you cannot... the guy would have had to sell him a cake because... Well, did he? Yeah, because it was... See, the thing that makes this... See, because sexuality isn't a suspect or quasi suspect class at the federal level, you're not going to have an equal protection thing come in. Or
he got away with it because it was religion,
and it was the issue. Remember, Colorado passed an anti-discrimination act that made sexuality a protected class, and that also complicated things.
Yes,
so
because it's not the federal.
It's not at the federal level. So the Supreme Court basically said that, he would have had to follow that Colorado law, right? He couldn't have even, if he wanted to say no gays buying any cakes, they would not have let him, because it would have ran afoul of the Colorado Anti-Discrimination Act.
Mm-hmm.
And so that's how the Supreme Court said. They basically upheld that part. And they said, no, you can't just outright discriminate against gays because of this state law. But you don't have to make a specific message for them. Like, you don't have to endorse the gay wedding with your art. They can't compel a guy who said, I'm an artist, I don't believe in this, I don't want to make this.
Because this isn't just... And part of another part of this that's important is that he wasn't just writing happy birthday on a cake. He classified himself as like a pastry artist, something higher level, where like it isn't going to Dairy Queen. This was him taking, hours to design and paint these cakes. So he did have that going for him as well. That they couldn't compel him to give up his talent, basically, his skill.
Yeah. So it's a messy case because it has a bunch of different legal theories going in it, and this Colorado state law that is more restrictive than the federal anti-discrimination laws. It ended up being in his favor. He didn't have to make the specific cake for them, but I mean, the guy they drug the guy through, years and years of legal issues. So, he ultimately, like I said, he ultimately won. But only on the artistic aspect, not by saying, I don't want to sell any of you my cakes. He still had to basically serve them. And this is the case, much like Rosa Parks and Plessy and all these, where they went in to buy the cake knowing he had this religious reputation that he probably
They went in with a lawyer.
Yeah, they already had a lawyer. And they went in basically planning just to mess with this guy. It's pretty terrible. So there was a question about churches, and
I did see that one. It was, could churches do it based on race?
Yeah.
That's tough, because religion has different tests than discrimination.
Is a church is a church a public accommodation? That's the first analysis of it. So if it's church a public accommodation, it's going to fall under civil rights jurisdiction, right?
Yeah.
So I'm looking up here at the law.
But
They're
I think
generally
that
not.
question was
So they're generally not public accommodations. So if they're not public accommodations, it's not going to be a Civil Rights Act issue. Um, so if they said whites only, and it's a group, and somebody wanted to challenge it, they would have to look at the purpose of it. Depending on the purpose,
yeah.
I think they might lose that.
I think they would too, thinking about it, that they would force it open, and if somebody wanted to attend that church. Now, you could change that scenario, and if you could pass
They could say only
the
Christians.
factors,
If it's a church, they could say like no atheists are allowed to come in or something.
yes.
But
Yeah.
if it's a race thing, it's I think they're going to get opened up. If it's real,
Unless your religion was based on race, which opens up a whole new set of factors. But
yes, that
that,
does. Yeah. So yeah, if it's not a public accommodation, but it is going to be a private group, and there's the case law on the private group, then. Um, so yeah, churches are very segregated. Naturally, people just tend to go to their own. It's one of the places that people don't seem to want to integrate. Um, but yeah, I think it's going to. If somebody challenged it, it would probably have to open it up. So
yeah.
that's all the presentation material we have. If have a couple minutes, we'll just chat.
Yeah, take some questions
Take any
if anyone's got
questions?
any.
Let me look through the chats here, man. They X tagged me. I'm gonna have to move somewhere.
Yeah, you got. I was looking at the browse thing. You were on top because you were the most viewed,
Mm-hmm.
but you're gone now.
Yeah.
Got the
Got the
got the
show up.
lock.
Got the show up, man. Let's see here. An ethno-religious group is probably an ethno-religious group is probably fine. Like if that's their official,
But the ethno has to be part of the religion.
it has to be part of the religion.
You
Yeah.
couldn't just do like we're doing Norse paganism, and since that was traditionally white, that's all we let in. Something like that wouldn't work.
Yeah. Or like what about the people that it's like there's the Greek Orthodox churches, Romanian Orthodox, Macedonian Orthodox. What about Russian Orthodox? If there was a Russian Orthodox church, and they said we only want Russians here, how would that look? Somebody said I'm not Russian, but I want to come.
Yeah, I don't think it would. I don't think it would work.
If they really wanted to challenge it, like I don't know, it would be that would be interesting. They might change things like you have to donate a certain amount to be involved in, and that's why we didn't let you, and we're waiving the
Yeah.
fee for ethnic Russians or something. I mean, there's probably some ways around it, but man, this stuff is like the person probably have standing, probably take you to court.
Yeah. Somebody asked about Robin Hood. Is it going to be cleaned out by class action? Class actions are so complicated. I was trying to explain it to a friend, like the one, like we learned in our one class that like class actions get settled basically like the second they start, and like the company agrees to like pay out to have the people notified, and that like goes into their settlement. So like that's and then people jump in later, and you're gonna get like $2. It's possible, but it also seems the way that you have to do class actions, like get a class certified, a judge has to sign off basically every step of the way. A case that got put into court like 30 seconds after they started messing around
Yeah.
as a class action doesn't seem like it's even going to go anywhere.
I don't know. It'd be interesting to see. They're probably going to be able to prove some damages, right? I mean, they did sort of.
Except for their indefinite damages. So,
Yeah,
like,
they're not definite. I guess you could. Yeah, it's going to be weird. And it's like, are the judges. The judges going to side with the fact that Robin Hood was trying to help Wall Street out? You know what I mean? There's like that real political angle.
yep.
Yeah.
Somebody asked about fundamentalist Mormons. Um, that I mean, the regular Jesus Christ and Latter Day Saints, they got opened up from their bad press
Yeah, I remember when
because
they
I
had to
don't know
came
if
out,
everyone knew
like they
that
said,
they said the darker skin you were, like the more touched by Satan you were.
yeah, that was their belief for a long, long time.
Yeah, and they had to change basically just from bad publicity. Now the fundamentalists, I don't know, but they're not. I don't think they're a. Like we were saying, a lot of these cases people walked into with lawyers. Like Rosa Parks was a setup,
Hmm.
Plessy was a setup, the Masterpiece Cake was a setup. The fundamentalists,
That's a really important part about
they're
civil
not
rights,
sexy.
is that
They're not
like
sexy.
these weren't always organic. These are setups, man. Like they were setups from the top down. Walked in with a lawyer, already had sympathetic judges that they were talking about. Hey, they had been wanting to uh, get rid of some of these things for a long time. Wanted the brown. They wanted school integration. They'd been talking about that forever. They basically ACLU basically bred some of these lawyers to do that. They paid for them to get through law school. They paid, helped them. It was just the whole thing, man. The people were groomed for this for a long time. It wasn't just the natural course of American history and law going that way. It wasn't like this society was bending towards racial integration. It was a setup. It's hostile
Uh,
takeover, bro.
yeah. Saxon Stargazer's asking about your law group being more of a firm or a lobbyist group.
It's definitely going to have the aspects of both. I already have quite a few clients I'm working with a range of topics, a range of issues, and some of it is stemming from the Capitol riots, and some isn't, but some of those are really wild. So we're already helping people out, dealing with various legal issues, and then that's the important thing right now. There's a real. You've probably seen the billboards in your town where the FBI is hunting these people, and the FBI is doing a lot of visiting people's work and homes and asking them about stuff they wrote online, and really intimidating a lot of people right now. Really, really scaring a lot of people. So that's a big thing we're working on now, and will probably continue to be for a little while. But going, a lot of what it ends up being is going to really depend on funding and my ability to get funding and secure it, and basically get people, either a lot of people donating a little bit, or a couple people donating a lot, or a combination thereof. And really, I would like to take it as far as I can go with it. I would love to do lobbying. I believe wholeheartedly that politicians are mostly empty vessels. I don't think most of them are ideologues. I think they can all be lobbied to do something. And I think it has. I think there's some power there. I think I don't think I don't know that there's a whole there's turning everything around, but I think there's a lot of people that we can still do to make things not totally worse. I think we can keep a lot of people out of jail, keep a lot of people from getting totally screwed over by the state. I think there's some future in some various real estate development, and that would depend on funding to get rolling. So yeah, it sort of depends. If you are here hanging out and want to support the cause, jump on Subscribestar or something. If that helps a lot, helps plan, helps kind of pay for stuff as I'm going, and helps plan kind of monthly. That's very helpful. I'll move to a different stream since now this is shutting it off. So I think, it's difficult right now because I only have so many hours in the day, and I'm already kind of spread thin. And there's people that need help immediately, but it keeps me from doing other things that are more lucrative. So yeah, I'm hoping it keeps going. I think if I just keep doing this, keep writing, keep doing some streams, keep helping people out legally, it'll work out.
Now, do you know if you since you got X'd, is that like your channel forever now, or
RC said people just can't donate now here?
Well, I mean, but if we in 2 weeks do did the Miyazaki stream?
Oh yeah, I think
would we be able to?
Oh yeah,
go
I don't know
back?
about that.
That's something we should look at, because maybe if we do in a couple of weeks, a totally just kind of fun one that won't get flagged.
I don't know. I think we probably ought to move anyway. Just if this is the way things are going. I'm not aware. Yeah. I know of Tom Kwasinski. I'm not sure how to say his last name. Kwasinski. I'm aware of him, but I'm not really aware of the Free State Project. So funding, ideally a year. I mean, it's one of those things that's scalable, of course. And the way I want to do things is that I, at a certain point, don't need much more funding. If everything's kind of held in trust with trust proceeds going towards, funding everything like salary for lawyers and whatnot. To start out, I'm kind of doing it now, but I am doing it now, already providing legal aid, and it's a lot of people that don't have a whole lot. So I'm not going to get a bunch of billable hours from people that kind of posted something edgy online or went to the Capitol because they were upset about the election. So I basically am doing it now on a shoestring to run, to hire other people. That's going to takes more money, obviously. So at least paying people salaries. There's people that are lawyers that believe in it, but you can't. There's so, like you said, you're spread so thin when you're doing any sort of legal work. It's hard. It would be very difficult to do it totally normally job and then do this kind of stuff too, other than extremely part-time. So
you see the one about funding prospective lawyers?
Yeah, that would be a very ideal scenario. At some point I want to train a bunch of people to do what I do and think this way, and kind of institutionalize the worldview and the process and the sort of boutique legal service that I want to provide. That would be a long-term goal, and I would definitely like to do that. If there's people in undergrad that were just getting into law school, or that were in law school and they contacted us, that would be really, really great, and something I definitely want to do. So, but to go back to the funding per year, see that it just depends. If you had 30, 40 people across the country, maybe somebody in every state, one person in every state getting a scholarship for a certain amount of money that went towards, maybe do some sort of, how they do it, essay. You write an essay about it or whatever, and it goes towards it. That could be, that could add up quickly if you hired, if you had 5 lawyers, 10 lawyers, depending on that, it would be much more money. The idea would be to do something like, where the office is in a building, like a mid-rise building, where we have the top floor we work in, and the other ones are all being rented out, and that's held in trust, and income goes kind of back towards the organization, paying bills and whatnot. That would be, stuff like that is the plan, not to just take indefinite, like to always need indefinite donations. Like, so you get to a point where all your expenses and salaries are being paid by stuff held in trust, and then anything on top of that is just sort of, could go to things like scholarships and outreach programs and different things like that. People get evicted and you have houses for them. You could really, really get into doing a lot of cool things as it goes further. So I think I'm going to wrap it up there. Been about 2 hours. Anybody got any last minute questions? Paul, you got anything to say?
No, I think it was a good stream. I hope we helped out with some people. Difficult subject area, but no, I think it's overall went pretty well.
Yeah, it is a difficult subject here. Even in law school, I think, like the 14th Amendment stuff, the equal protection stuff, that's hard stuff for people.
Yeah,
I mean, what were some of the stuff?
And just because there's no logic.
There's no logic. And what's some of the other stuff we did in constitutional law that was like easier? I mean, what was hard and what was easy?
Like, a lot of this was obviously hard. Free speech is challenging because you have where you can do it and where you can't do it.
That can get complicated. The form analysis gets a little complicated. What was some of the stuff? Yeah. What were I'm trying to think of the one essay we had in con law, and it was about, wasn't about, oh shoot, what was it about? You had rights, somebody took someone's license, and what were those issues? Do you remember?
Yeah, that was like powers kind of thing, like what the...
Oh, we had a powers, but there was another subject.
Able to do.
There was a subject in something. Shit, what was it? Was it deprivation? It wasn't like, it was almost a taking. Not like a Fifth Amendment taking, but there was something where it was like, your state's doing this to you. Do you remember? I'm trying to think of the essay scenario, but what do you mean community building? I'm not sure exactly what you mean by communicating, Saxon. Like, I have a group here. Just had a big meetup last night at an old pizza place. It was super cool. One buddy got out of hand, but he always does. He's always out of control. So I'll announce on Twitter some we're going to stream next, and
maybe we'll break it in with an easy one.
Yeah, I'm not sure. We don't really have, the first 3 episodes are planned, and I don't really have the next episode planned yet. Episode 4, I'm not sure what we're going to do. Something law/academic related. That's what Wild Rich doing. If any of you guys have any suggestions now, stuff you'd like to hear about, you can throw it out there. See, civil rights, even though it was a quick rundown, and free speech, those are some big areas that like our political sphere cares about.
Yes, but I think we could get into other interesting topics that our sphere cares about, like an industrial society and how it relates to...
That'd be a good one. We could do...
film or... just take it into the kind of general higher level stuff. I would love to do, I mean, I don't think anyone else would like to hear it because I'm the big old nerd, but I would love to do rundowns on early American history because I think understanding the the Declaration and the Constitution and how they flow together really really matter when it comes to later making these arguments when people talk about it.
Um, yeah, that might be an interesting show, and also do like what would we add? How would like a new constitution, like a modified? What would you modify? Would you keep it? Would you throw the whole stuff away and start over?
Oh,
Be,
2A stuff, that would be
we could
interesting.
do a good Second Amendment. Actually, maybe that'll be the next one. We could put together a really good Second Amendment, some law, some outcomes. We could do a real good one. That I don't know. Somebody asked about the churches and Benedictine option. I don't know anything about those. And then for in real life stuff and actual towns, yeah, one of the things I'm really interested in is city planning and like real estate development, and that's what I almost went into instead of law school when I was going to pick a grad school. And I still like I don't want to say I regret law school because I passed the bar. If I failed the bar, I'd totally regret it. It would have been the worst fucking 3 years of my life. but tell you what, when you getting that, like seeing your name on the pass list, that made a whole lot of shit go away. Tell you that much. Didn't it, Paul? Like, didn't that just make a lot of the shit worth it?
Yeah, it did, because, I mean, your life still might suck, but at least you're a lawyer.
Yeah, like, yeah, man. Yeah. So a Second Amendment thing would be good. We could do we could get into the history of it.
Yes, I would like to do that. That could be a very good one.
And some of the laws are cool, like the 1934 Act, even though it's bullshit. It's like, they had the St. Valentine's Day Massacre, and then who'd they almost assassinate? FDR? Was it FDR got shot at and was pissed off?
Well, no, Reagan got shot.
No, in 1934, when the NFA came about. That would have been FDR, right? He was president in 34?
Yeah. Did somebody take a shot at him?
Yeah, somebody took a shot at him, and he was like, fuck this, you can't have no more guns. You're just using them to shoot my communist sympathizing ass surrounded by J people in my brain trust. No, you can't shoot at me no more. Yeah, he cried, man.
We can't have...
I wish I was around so I could have tweeted at FDR, be like, oh, you got shot at, you gonna cry? You gonna suck your thumb? Going to outlaw machine guns now, you little bitch?
Yeah, or like the mob just mowing people down with Thompsons.
Yeah, they're like, you can't have a Tommy gun. You're not allowed to have a Tommy gun because this one dude might kill all his rivals with it. Like, bro, what? That's stupid. Well, they had the... you could have it. You could just have to pay the $200 tax, which was like $3,300 at the time. And it's still funny that they never changed it. Like, it's still $200. And it's, like... I can't believe they never changed it.
Now, if you want a teaser for some of this, me and Rich have talked about this before. We both believe that you should be able to get grenades out of the vending machine next to the Coke machine.
Yeah, I argued in our Second Amendment class that if the government has predator drones, I absolutely need anti-predator drone weaponry.
I need a Stinger.
Yeah. That I literally argued that like if we take the Second Amendment at its face and its original intent, that if the government has a tank or a destroyer ship, I need the equivalent of that at least, at the least, like, and they didn't really quite buy it, but because they're stupid. Like, that is, I mean, when the British were coming over with ships with cannons, like, the revolutionaries had ships with cannons too. That was the whole friggin' point, They weren't just...
stopped scaling. The technology stopped scaling.
Yeah, the technology stopped scaling. So, like, I get that, like, a rifle is cool or whatever, and it is helpful, as the Afghanis and Vietnamese and whatnot proved. But, if heads of state are going to go on Twitter and like make jokes about predator striking me, like, bro, I need something to protect myself. I need my own predator drone at 70,000 square feet circling my airspace to make sure nobody fucks around. Like, it's just not even. It's just screwed up, man. I don't believe. What a stupid country, you know?
Yeah.
Yeah, like, why can't I buy, like, I need a tank if they have tanks. Like, if they're going to roll, and somebody was like, that's not going to happen, because I made the comment about I need an anti-tank weaponry.
Yes,
and they were like,
this was great.
Yeah, and
Like,
they were like, when's that going to happen? And then Paul was sitting next to me, and he goes, it literally happened in Waco. And then the guy just shut the fuck up. And and yeah.
Well, actually, the best one, and we're giving away. We'll tell this when we do it. But he was like, the guy was like, I walked through the killing fields of Cambodia, and he was like, what do you like? Do you think they liked guns? And and Rich was like, yeah, I think that. He was like, do you think the Cambodian, or who do you think in Cambodia would want guns? And he was like, well, probably the dead Cambo.
Yeah, the dude was like, I actually saw bones sticking up in the killing fields. How do you think they would have felt about the guns? And I was like, they probably would have wished they had one. Like, duh.
To the guy's face.
Yeah. Oh yeah, dude. Paul kept like hitting me because I was just bouncing on this fucking old boomer so hard. I basically was like, this is my class now. You're not going to get up here and talk your anti-gun bullshit. And yeah, he almost cried. Like, I was like, and then if he did, I was going to be like, you going to cry? You going to suck your thumb? This was like way after I got swatted and shit. And I just basically wanted to be a total menace at that point forward. Any good? Well, Randy Weaver wrote a book about Ruby Ridge. Waco, there was a recent So basically, the deal with Waco is that the official story is that a unidentified anonymous informant who was allegedly a postal carrier said that they were raping kids in Waco. And therefore, the government went in and killed all the kids. So to stop them from allegedly being raped, they burned them alive.
And there was the story that there might have been a short barrel, which is why the ATF was there to screw everything up.
Yeah. So, yeah, maybe Paul, we should. I'll reread. Well, you get a copy. I'll reread Randy Weaver's book. Maybe we'll do some Waco stuff. And
yeah, that could be another. Yeah.
And then we'll like do Waco Ruby Ridge Second Amendment show.
Okay.
So let's see. Do you think restrictions on 2A stuff can also apply to universal health care, as it wouldn't work in our current society, but it could work? I'm not sure what you mean by the restrictions on it and apply to universal. Like, yeah, I'm not sure. I really don't understand the question. Do you?
No, I don't. I was looking at it. Do you think restrictions on 2A stuff can apply to universal health care? Yeah, I'm not 100% sure what you mean there.
I mean, I get some stuff like so I'm actually yeah, I don't want to live in a society where you need to carry a gun around, John. That's like a great point, and I actually we can talk about that in the episode too, because I hate the libertarian talking point. I'll get people messaging me or commenting on like 7-Eleven nationalism, where I'm like, hey, it's kind of bullshit. I can't just walk in into the 7-Eleven at 2 in the morning with and not get mugged. And they're like, well, just carry a gun. I'm like, well, I do, but I don't. Like, do I really need to be ready for a shootout when I'm getting a big gulp of Pepsi? Like, bro, I just want to I want to get a fucking Pepsi, 6-pack of beer, and go home with this girl. I don't want to, like, spend all night in prison and, go through. So, yeah, I totally get it. I think, ideally you wouldn't need it, or you would have a government that was so in line with your views that you wouldn't be worried about an anti-predator drone weapon. Like, that would, of course, be ideal. So I think some of this exists on a sliding scale where it's like, right now, maybe to curtail the government, you need that, but it wouldn't have to exist. So yeah, there's the argument of like what you believe now versus an ideal society. Like do I want, 15-year-olds in the ghetto with access to fully automatic Mac 10s with extendo clips? No. I don't think they should have. No, they definitely, like, I'm not in like in the like 2A absolutionist, it has some carve outs, and that's one of them, right? Like, I don't think that's for them. But if we live in a society, we live in a society. That's it.
I saw Saxon. Yes, I think everything's a little different in an ethnocentric society. Universal healthcare could work because you trust the person going to the hospital is there for kind of a legitimate reason. Like, they,
yeah,
that's how I think universal healthcare works. That's the reason I don't think it works now, is because I've known EMTs who tell me that, like, fat people will get like rides closer to where they're going by just saying they're having a heart attack, and the hospital's closer to the McDonald's than like having to walk or something. Like, it's stuff like that.
Yeah, people using the emergency room for like a cough because they don't have to pay for it, and it's weird.
Yeah.
So, yeah, like, I don't know. There was a oh yeah, you could let them cleanse themselves. Yeah, you could. But I mean, I guess it's just like, I don't want them shooting at me, and they're going to. Or I don't want to be around them when they have the Mac 10 that's automatic with extendo clips, maybe.
They're not. The problem is they're not staying in Detroit.
Yeah, they come out to like where we like to go to the mall, and instead of them throwing a can of Coke at each other and I have to dodge that, now I'm dodging bullets again. So there's that issue. Robin Riley just wrote an interesting article. If you follow her on Twitter, she's on Instagram, she's on Twitter, but she posted the article to Instagram. I don't know if she posted it to Twitter, but it was about the universal healthcare in Canada and how, like, it's not, their system isn't good. So it would have to be, if you had a universal healthcare, and see, I think it would need to be, I don't know, it would have, there's so many things about it, man. The Canada system isn't ideal either. You have better healthcare here, but the expense of it's different. I think a lot needs restructured, but I don't know that all the models now are great. I think it's something you could improve on. I was big advocate in the Obamacare area for a regulation on insurance companies. So, like, saying they can't deny, like, if you have insurance and then they say this was a pre-existing condition, we don't cover it, like, you stop them from doing that. And then you put certain limits on insurance companies. You don't nationalize them, but you basically say, hey, there's some laws here, and you can't screw these people the way you're screwing them. I advocated for something like that. Of course, nobody ever listens to me. They went with something that didn't really work that well. So, I don't know.
So, we're at 2:15 now.
All right, let's let's wrap
before
it up.
we jump off, I would like to just do a shameless plug for my new Twitter. I got off right before the bar exam, and I took some people's advice and got a pseudonym. So if you would like to follow me on Twitter on the new one, it's PG_burner. I would thank you for that, and thanks for listening, and hope you enjoyed us.
Yeah, follow him on Twitter. That'd be cool. Yeah, like, Japan has they have a weight thing on universal healthcare. I think they get fined if they're like overweight or something. They have something there that essentially stops. Basically, they recognize that if they're all pooling their money for healthcare, that people who are abusing their weight are unfairly burdening the others. Where in America, that's encouraged to, like, they're like, yeah, do whatever you want, and some white person will pay for it. So I don't know. So yeah, follow Paul on Twitter. If you want to support the war effort, jump on Subscribestar. I post updates there. That helps a lot.
Yeah, thanks for everyone who donated
Thanks
before
for all the donations. I hope
the
they let
lockdown.
me. Hope they let me take them out. Like it's weird how they do that. Well,
might have to honestly do one more on here just to hit your hour count.
I think I'll do like an AMA next week or something, and then hit it and see if they let me take it out after. If not, I'll probably look through the terms and conditions, see if I have to sue them to get my money, and see if I have any standing here to get them. And yeah. So I think that's it. We'll do a show in 2 weeks. I think we're going to do the 2A. Do we have time? Do you have time to read 2 books in 2 weeks?
Yeah, it just depends on how things shape up.
I mean, we probably don't have to read a Waco. We probably don't actually need to read books on either, but I thought at least maybe you read one and I'll read the other, and then we'll like kind of do a quick presentation on each one, and then you know what I mean?
Yeah.
Like you read the Randy Weaver one, I read or vice versa, and then one of us knows about it, and then somebody said lemons do work again. What? Is that for real?
I don't have lemons.
Send all the Lamborghinis. Send Lamborghinis and lawyers and what is it? Guns. What is it? What's the song? Lawyers, guns, and money. Send that.
Yeah.
Help. Need lawyers, guns, and money. So, yeah, I think we're going to do the 2A episode. We're going to do some history. We're going to do the laws. We're going to talk about... what else are we going to talk about?
For next week?
The 2 weeks. When we do the 2A. We're hit Ruby Ridge,
we could probably
Waco.
talk a little bit about the history.
We should talk about the originalism of like what the whole point was.
Yes, I know that pretty well.
And then we should probably talk about like just general self-defense, because a lot of
yeah, we could also get into a little bit of the criminal aspect of if you need to self-defense. Here are some of the steps that you're going to go through.
Yeah, we should probably explain like self-defense as an affirmative defense, not just the like, I did a self-defense, goodbye. It's like, you're still getting charged with murder or whatever, like, and you have to prove you did a proper self-defense. So like that is an important thing that people need to be made aware of. We should maybe talk, what else? Maybe red flag laws. We can throw red flag laws in there.
Throw red flags in there, and then maybe we can just talk a little bit about the just generally how complicated some of it is, like with the
rights restoration and stuff like that.
Yeah, the restoration, because if you do lose your rights, you will be able to get it back.
Yeah, depending on what you lost the rights for, you can get it back. So we can maybe do that.
If there's, so my Twitter should be open, and I obviously have less people following than Rich. If you had an idea about the 2A or a question that you wanted answered, maybe and weren't in chat or something like that, just send me a message.
Joe, I don't know what you mean. The people that aren't getting their money from donation sites. I'm not sure.
Like represent them as a lawyer when you sue them.
Oh, yes, okay. Yeah, okay, I guess dilemmas don't work.
Yeah, so we'll put together a good 2A show and do some.
Yeah, I don't know what the Twinkie defense is. What's the Twinkie defense, Sizzlers?
The Twinkie defense is from Harvey Milk, the gay councilman from San Francisco.
Yeah, what did he do with Twinkies?
He got shot. One of the people he worked with killed him.
Yeah.
And it was like the defense he said put on was like he'd been eating so many Twinkies and like the high fructose corn syrup like messed his mind up, and he wasn't in a good place, and he got like 5 years for murder.
Oh, so shit. Okay. You know what? We could talk about what was the dude's name? The Jewish dude in the subway that shot the 5 urban youth.
Oh yeah.
What's his name?
Oh, I can't think of it. It
starts with a G, right?
They love to talk about that one.
What was his name? He starts with a G.
New York subway.
Was it G?
It is. Those are the victims. Oh yeah, Bernard Goetz.
Oh yeah, Bernard Goetz. Yeah.
Or Getz.
Yeah,
Goetz.
Bernie Goetz. Okay, yeah, we'll talk about Bernie Goetz. He's a Jewish guy, but everyone calls him white because of what he did. I guess that's honor. I guess he's an honorary, right? I mean, he just went straight up fucking. What's that movie, dude? Death Wish.
John Wick.
What were you gonna say?
I said John Wick.
No, this like, well, yeah, I guess John Wick too, but more like Death Wish because it was like gritty New York subway in the 80s, man. Total like Central Park was called Needle Park back then. Graffiti all up on the subways. These dudes pulled a screwdriver on him and were like, "Give us your money," and he was like, "I got something for you," and then he and then in absolute like Batman style, unloaded the mag on him. One dude, well, he didn't. Well, I guess it wasn't a mag. It was a revolver.
It was a revolver.
But then, like, a dude was on the ground that he didn't kill, and he looks at him and puts one more in him. Bam! Takes his last shot with his .38 special. Puts his shit back in his pocket. Gets off the subway. Walks into the tunnel and disappears for like 2 weeks. Dude, that's. I mean, you know what? He can be white. I don't care. Yeah, that was Bernie Goetz. I remember when that class came up in law school, everyone was like, and then this white guy, and then it was remember our professor at the time was a Jewish fellow? Yeah. And he like got this look on his face like, yeah, Bernie gets to be white for this. I'm not claiming Bernie because Bernie gets like, you know, shot these urban youths up. And they're all like, the people were like, they were only like 15 and they only had screwdrivers. I'm like, bro, have you ever seen a 15-year-old black kid? First of all, they're all the way grown. Second of all, do you want stabbed with a fucking Phillips screwdriver in the kidney? No. Like, they were making it seem like all they had screwdrivers. Why do you had to shoot them? Yeah, I said, you don't look so bad. Here, have another. Yeah, that's what he said to the dude laying on the floor. I mean, literally like shit from a movie. Bernie Goetz, man. Yeah, we're talking about Bernie Goetz. For sure. This is going to be a good episode, even though we gave you a preview for the whole thing.
All right. Yeah, we'll get that working for a couple weeks.
All right, we'll do that. Yeah, you don't look so bad. Have another. Like, that's literally like you feeling lucky, punk. I mean, the dude went full Clint Eastwood on there, man. He's kind of like a one-man subway right-wing death squad. Literally did full Gen Row on them fuckers. I mean, they should make an anime about him, dude, where he just like rides the subways and cleaning up filth. Maybe that'll be my next comic book I have made. Like, it'll just be